For decades, many Canadians, including myself, believe forced sterilization of Indigenous women ended with the 1982 Charter of Rights and Freedoms. Section 7 guarantees personal security and Section 15 ensures equality. These provisions should have safeguarded Indigenous Canadian women from human rights abuses like forced sterilization. However, the truth is that forced and coerced sterilization of Indigenous women in Canada did not stop after 1982, and in fact continues well into the 21st century. This is more than a violation of medical ethics, it is a clear breach of constitutional rights, human rights, and provincial consent laws. Forced sterilization in Canada stems from eugenics, the belief in controlling reproduction to improve society. Alberta and British Columbia passed sterilization laws targeting those deemed unfit, disproportionately affecting Indigenous women. Over time, it became increasingly clear that these laws disproportionately targeted Indigenous women, who were often misled or coerced into undergoing sterilization procedures, with Alberta's Eugenics Board approving over 4,785 cases at a 99% rate. Even in instances where consent was obtained, the power imbalance made it impossible to know how many women were truly making voluntary decisions. Though these laws were repealed in the 1970s, the question remains, did forced sterilization truly end, or did it just continue under a different disguise? Despite these repeals and the introduction of the Canadian Charter of Rights and Freedoms in 1982, forced sterilization continues today, particularly among Indigenous women. Even though the Charter guarantees protection of bodily autonomy and freedom from discrimination, including reproductive autonomy, legal protections mean nothing if they are not enforced. In fact, Indigenous women have continued to experience forced and coerced sterilization well into the 21st century. In 2017, attorney Alyssa Lombard of Maurice Law filed a class action lawsuit in Saskatchewan on behalf of 60 Indigenous women who were sterilized without their full and informed consent between 2008 and 2017. Many of these women reported being sterilized immediately after childbirth, while still in medical distress, often while heavily medicated or recovering from surgery. Some women were directly misled, being told that tubal ligation was a medically necessary procedure for their health. Others were outright threatened. Some were told that they would not be allowed to see their newborns unless they agreed to sterilization, while others were made to believe they would lose access to government benefits if they refused. The Saskatchewan lawsuit specifically argued that these procedures violated Section 7 of the Charter by stripping these women of their bodily autonomy and security of the person, and Section 15, as Indigenous women were specifically targeted, continuing a pattern of racial discrimination within the medical system. This case directly contradicts the belief that forced sterilization ended after 1982 and highlights the failure of legal protections in practice. Beyond the Charter, Canada's provincial laws regulate medical consent. Ontario's Healthcare Consent Act, introduced in 1996, ensures patients have full control over medical decisions. Valid consent must meet 4 criteria. It must relate to the treatment, be informed, be voluntary, and given by a capable patient. Yet, many Indigenous women were sterilized without meeting these standards. Some were unaware they had been sterilized until later, while others were misled, told it was routine or necessary. Many were pressured with threats of losing their newborns or medical care. Some were sterilized while in labor or under anesthesia, making true consent impossible. While the HCCA applies to Ontario, similar laws exist in other provinces and territories, all of which were violated in these cases. Perhaps the most shocking recent example of forced sterilization of Indigenous women occurred in the Northwest Territories in 2019. Dr. Andrew Kotaska, a senior physician at Stanton Territorial Hospital in Yellowknife, sterilized an Inuit woman without her informed consent. She had only consented to the removal of one fallopian tube due to medical concerns, but both were removed without her knowledge, permanently preventing her from having children. Despite objections from other medical staff, the procedure was carried out and later deemed completely unjustified. In May 2023, Dr. Kotaska received a 5-month suspension, a $20,000 fine, and ethics training, but no criminal charges. His actions violated Section 7 of the Charter, stripped her bodily autonomy, and Section 15, as she was an Indigenous woman subjected to medical discrimination. This case proves forced sterilization remains an ongoing reality in Canada, despite legal protections. The belief that forced sterilization ended after 1982 is a myth. It is truthiness. The Canadian Charter of Rights and Freedoms has not stopped Indigenous women from being sterilized against their will. Provincial laws requiring informed, voluntary, and capable consent have also failed to protect them. Cases like the Saskatchewan class action lawsuit and the Northwest Territories incident prove these violations continue today. Yet, the government has not held doctors criminally accountable, failing to enforce its own laws on Indigenous reproductive rights. Until perpetrators face prosecution, stronger legal enforcement, and systemic healthcare reforms, Indigenous women remain at risk. Forced sterilization is not history. It is a human rights violation still happening today.